If it's Thursday, that must mean we're conducting a webinar. And as always, it's good to be here. I'm Chris Hines, Strata Advisor for Hines Legal, former Commissioner for Body Corporate and Community Management. Frank Higginson's been unavoidably detained at this point, hoping to see Frank in the very near future joining us on the webinar. Thanks to everybody who's registered to be part of the webinar today. It's the way that you get information afterwards. It's also the way that you get informed of topics which are coming up in the near future. So I just encourage everybody, make sure that you register when the link goes out during the week, and stay tuned for our next round of webinar topics, which we'll be announcing usually at the start of every month. So we'll have a new set of topics for you for April. Also, don't forget to like and share us on our various social media platforms, because again, that's the way you can get a bit of discussion happening, and also the way that we can generate different topics for future webinars. Today is the second in our series of Ask a Body Corporate Expert Anything. So we last did this one about 2 months ago, and seemed to go quite well, so we thought we'd give it another try today. So any body corporate topic that you'd like on any issue, and we'll try and give you an answer. Just a bit of a disclaimer though, we're not here to give legal advice, so if you've got an involved question that is about a pretty technical or complex legal issue, we can't really answer that one. We're only really here to give quite general information and guidance, and again, it's not legal advice that we're giving today. I just want to make that clear up front. We have had a couple of questions posed to us to begin with, so we might get into a few of those, but if you're watching this one live, just post a question into the chat feature on YouTube, and I'll pick those up as we go along, and we'll try to get to as many of those as possible. And if you're watching this after the event, so not live, but a recording, drop a question in there as well, and we'll get to that in the not too distant future. Let me just have a look and see what questions we've got. Okay, so we'll get on to the first of our pre-supplied questions, and we run. It's always interesting for this kind of thing to see if we get a theme or a recurring set of topics. We haven't really got one this time around, but maybe something will emerge as we go along. So first question. The chairperson who was not on the committee when they had renovations done to their unit, but then took over as chairperson, spent a fair amount of money on different things such as new carpet and stairwells, concreting walkways, and then there's a bit more discussion about it. The person then stayed only 11 months, and when the unit was sold, there was a realisation that person had done quite a bit of additional work as well. And then a realisation that they had damaged the hot water pipe when the builder had done the renovation, and they must have known that they were responsible for the damage. Imposed a levy on all the tenants to pay for the new hot water lines to be run from common hot water to the 4 units. There are 8 units in the block, and they really should have paid for it. And the person goes on to talk about how they've spoken to QBCC, but nothing has happened there. So what can the new committee do to make this person pay? It's a good question. Once a person ceases to be an owner, then there is no capacity to pursue them for a body corporate debt. Well, let me rephrase that. The only capacity after that is to seek legal advice and initiate legal proceedings if you think that there is an actual debt that can be pursued. But it's not a debt that can be pursued by the usual means. So say, for example, it's not a debt that can be pursued under body corporate legislation. If you haven't done so already, you might like to seek some legal advice about that particular question. You might like to look at issuing a letter of demand. And if you just bear with me, I will introduce Frank into the discussion.
And I can only apologise because I had 2:30 in my head. Despite doing these for 12 months, I had 2:30 in my head as start time, and I was just trundling away doing my work, and then I listened to your message and thought, oh my goodness. So apologies.
That's hilarious that you.
And I haven't even been drinking.
No, well,
Horribly
not much.
vague.
Not
No.
much anyway. Everybody, Frank Higginson. Frank, welcome. Frank, we're just sort of midway through the first of the pre-supplied questions. Yeah.
Okay.
So this is the one about someone who thinks that a former committee member who's no longer an owner in the scheme has done work which charged for out of body corporate funds, but really should have been an individual expense, and what they can do to pursue that person afterwards. And I was just saying, well, seek legal advice about whatever legal options that you have, but it's not a body corporate debt as it would traditionally be.
No, definitely not. And I suppose it's easy to throw those allegations around, and that's not to say they're not right, but it's the evidence in these things that happen that you're going to need before you do anything. So it is really a matter of characterising the expense was properly an owner's expense that wasn't a body corporate expense despite it being paid that way. Because I suppose, I mean, maintenance disputes, which is really maintenance and property repair and all those sort of things. I think, Chris, in your time, we're number one in the Commissioner's office in terms of disputes, and still remain that way today because it's confusing. Like, I mean, I suppose you see, both of us like giving black and white answers on things. It's really hard with maintenance. So in that sense, probably what comes up with those sort of allegations for me from time to time is it may well be an innocent mistake. That happens a lot. In relation to this sort of spending, and both ways. We've helped clients, particularly in building format plans, who are repairing roofs and all those sorts of things, paying for it for them by themselves when it is a body corporate expense. So that's a messy situation, and everyone's operating usually in good faith, but it can be very confusing. So I suppose, and from there, it really would be if it was, I think that gets messy in terms of spending proper money on legal advice, because it really depends on how much you're talking about. If you're talking about $2,000 worth of expenditure, there's no point talking to us really commercially about whether it's worth doing something about that, because you're going to spend that much on us anyway, and you're not going to get that back. Leaving aside, if it is a suggestion that you go and do something, the costs of actually doing that are going to be well more than the $2,000 you're talking about.
That's right. I think, Frank, your point about being sure of what you're actually talking about there is a really good one. I attended a body corporate committee meeting just this week gone by, and there was a very, very lengthy discussion about improvement to common property and whether something was or was not common property. All well and good. And one party was absolutely adamant something was not common property. The other party was adamant it was. And I'm watching this debate go on between the two parties just so strongly. And the interesting thing to me was nobody actually ever at any stage piped up and said, I believe it's common property or I believe it's not, because it was always based upon, well, clearly it's not. Well, obviously it's not. Whenever anybody says the word obviously or clearly in a body corporate context, that's always a red flag for me, because there are very, very few things in body corporate world in Queensland that are obvious or clear. So that's our little lesson for the day. Rarely.
And even, giving advice on those things for me is I want to see a copy of the survey plan, I want to see a copy of the CMS, and I usually want to see actual pictures of the area. So just photos, just give me photos of what you're talking about, because it really is, we need to see this, and into that mix goes all of that bits of information, and out of that comes out, well, we think it belongs to whoever, but it's usually never as black and white as what, I suppose, as Chris was saying, it might seem to some people.
Absolutely. Let's move on to the next question. Our question is sorry, I'll start again. If a complaint is lodged against a resident, is the committee obliged to obtain all details in relation to the complaint from all parties involved prior to the committee meeting to discuss the complaint and the issuing of apology letters to supposed offended parties? There's a lot to unpack in that one. Where to begin?
Well, apology letters. You ever seen an order which an apology letter was granted, Chris?
Never. It kind of reminds me of The Simpsons and Homer's great big chocolate apology cake. which he demanded of Lisa at one moment. Anyway, let's put that to one side. There's no scope to issue apologies in a body corporate context. So an adjudicator can't order an apology. There's no provision for apologies under body corporate legislation. And Frank, I would think it's highly dangerous for anybody to be issuing an apology from a legal point of view without it being
Yeah, I
looked at first.
yeah, I get there. And it's like sometimes that's all it takes to get something to go away. Because I mean, this is the thing. And again, I'll give you credit for it. You years ago, you've used the line at one of the seminars we were doing together when you were commissioner, and it's like you're never going to be able to legislate human behaviour. And that's what a lot of this stuff actually is. So I think asking for, demanding, or getting upset if you don't get apologies, in a sense, in Strata is going to be something that is going to be fraught with danger in the long term because it's unlikely to happen.
Yep.
So you might as well be starting by trying to get something that's achievable. But I suppose at the start of this question, you know, if a complaint's lodged against a resident, the committee obliged to obtain details, et cetera, et cetera. So I think for me, it comes back to what is the committee's job. So the committee's got a couple of statutory roles. Firstly, it's enforcing bylaws. That's, you know, it's managing the common property in a way that keeps it in good repair and condition, as examples. Is the committee obliged to investigate complaints? Possibly not. To the extent.
Well, I mean, let's talk about that.
Yeah, okay.
Are they? I don't think they are.
They're obliged to act reasonably.
Yep. But they're not investigators, are they?
No. Is the Commissioner's office?
No.
No. No. It's the legislation, I suppose, gives aggrieved parties the rights to do certain things. So if I'm writing in to the committee to say that Chris spoke to me nastily at the pool the other day, what is the committee supposed to do about that?
Conduct a wide-ranging inquiry. Do they take statements from everybody who is? Yeah, why not?
People on oath. Yeah. No, the answer is no. So, I mean, the committee's there to make decisions. It's there to do certain things in relation to enforcement of bylaws and the like. So I suppose the common example, and I think we've used this in one of these webinars before, Chris, would be pets. You know, Chris's dog is barking incessantly. That's a complaint. Chris's dog has been barking at 8:30 at night till 10:30 on the 15th of June, and this time, and this time, and this time, and this time. And here's the evidence of that.
Yep.
Attached to this in a USB or a Dropbox, and I'm asking you, committee, to please go and enforce the bylaws because his dog is causing a nuisance. That is something that the committee, to me, would have an obligation to do something about. Yeah. Chris's dog is barking a lot. Okay, what do you want us to do about that, mate? I think is you know, a legitimate response. If the committee is being asked to do something, it's not for an owner to just send it on a wild goose chase. To me, it's for an owner to ask it to do something specifically that's within its powers, and ideally something that it's got a statutory obligation to do with. And at that stage, the committee can then assess what and how it responds to that particular request.
Yeah, I agree, Frank. And then getting back to the second part of that question about is it necessary to gather information prior to the issuing of apology letters? If you're going to be issuing an apology letter, then I can't see how you can do that without getting information from all the parties. I mean, are you saying that you would issue an apology merely on the basis of one complaint that hasn't been substantiated, verified? I don't think you'd do that, would you? No. So look, by all means, if you're on the committee and you want to have a complaints handling policy, and that might work for a particularly large building, for example, sure, do so, but you've got to make sure that you've crossed all the T's and dotted all the I's in that process, and that means you have to give everybody a right of reply.
And that's natural justice, isn't it?
Yeah.
So I suppose I'd probably coin the two words or phrases that probably matter for this one is natural justice, in terms of if someone's been accused of something, then they're entitled absolutely to have a response to that accusation before things go out to all and sundry. And the other one would be defamation.
Yep.
You know, Chris is taking money from the body corporate accounts. That's a complaint, but it's also defamatory if it's not true.
That's right. That's right.
Yeah, so you've got to be really careful on those things. It's sort of, and I suppose that's part of what people think committees have these wide-ranging investigative powers or obligations when they actually don't. They're still volunteers in a volunteer capacity, most of which, probably 99.9%, aren't paid and have some other form of day job or other interests to deal with other than running star chambers for bodies corporate.
Definitely. Thank you for that question. For that party, I'm tending not to use people's names, don't want to identify, but thank you. Frank, we're continuing to get a whole bunch of general inquiries, general questions about committee meetings, general meeting processes, whether an owner can still lodge a motion if they are unfinancial, aren't we?
Yes. Yeah, the new regulations have stirred a whole lot of interest now. It's sort of, there was 6 months worth of arrival, and now they've, 18 days into it, the inquiry rate in terms of that is off the roof. Charts.
Yep, charts. I think charts. Yeah, yeah. So I mean, okay. So what's the position then?
Oh where I suppose people get removed from the right to vote, both now at committee level and at general meeting level, is if they're unfinancial. So unfinancial means they haven't paid a body corporate debt. So I suppose there's been a raft of litigation about what body corporate debts are. It's not simply every cent you might owe the body corporate, but it's certainly every cent that you might owe them on a levy statement in relation to admin and sinking funds and interest and penalties and those sort of things. So if owners aren't financial at general meeting, they can't vote. If committee members now aren't financial, or their nominators aren't financial at the time of a committee vote, they can't vote. But unfinancial people can still lodge motions. So I suppose in a sense what that's saying is you can still put something up, but you're not going to have the ability to influence the outcome of it if you're not financial at the time. So that financial element takes away your ability to participate in the decision making of the body corporate, as opposed to put something before the body corporate for consideration.
Yep, definitely.
Yeah.
The bottom line is, and I think the legislation is now such that if you want something properly considered at a body corporate meeting of any type, you better make sure that you're paid up in doing so. Otherwise, your entitlement to have that considered really just isn't there. We're also getting a whole bunch of questions about quorums, aren't we, Frank?
Yes.
So let's address the first thing. What's a quorum generally? So there's a lot of different ways that you can explain what a quorum is, but I think the simplest way is a quorum is the minimum number that gives legitimacy to any meeting. Would you agree, Frank?
Yeah. How many people are required to, I suppose, have participated or be there to allow a meeting to start?
Yep.
And I think for me, the big one.
Yeah, I think that's the really good point, actually, Frank. To start.
To start. Yep. And so people can leave halfway through, but they were there at the time it started, which means the meeting will still continue. So that's something that comes up quite a bit as well when people walk out halfway. No, we don't have a quorum anymore. Yes, we do, because we had it at the time the meeting actually started. So, and quorum for me, did you ever look this up in terms of Latin?
I did. Now
you
it
did
escapes
somewhere.
me.
Yeah, no. It
comes from the word was cora, and it means. All right, keep talking. I'm going to look it up.
I'll kill you on that one. Sorry. So, and the big thing in body corporate, and it's a sense, you do look at it sometimes and say you don't even know why it's there. A quorum for a general meeting is the number of voters required to start a meeting. It's not the number of lots in the scheme. That's something that gets lost all the time. So a voter is someone who's entitled to participate in the meeting, of course, as the owner of a lot or a proxy or a corporate nominee or whatever it might be. But those voters are not necessarily the same as the number of lots. So if I'm in a body corporate and I own 50 of the lots myself, as much as I've got 50 votes at a general meeting, I've only got one vote. I'm only one voter for the purposes of calculating a quorum, which is a really, really important distinction. So this is a nightmare sometimes for body corporate managers and committees, I suppose, who are trying to figure out, do we have the requisite number of voters here to actually kick this meeting off? So, and probably, Chris, the reason that we're getting asked this a lot now is because the government, for the first time, has given bodies corporates the ability to regulate or to change the number of voters that was required to be at a meeting to allow it to commence. So previously, it was 2 people present in person and 25% of the voters. So now a body corporate can change that to 1 person present in person, which can now be electronically as well, and up to or no less than 10% of the voters. So Again, that's got to be done. I think special resolution, Chris?
Yes, that's right.
So that's effectively 2/3 of those people vote in favour of it. And of course, if you do put that on the agenda for your general meeting at some stage, it's not going to apply to that meeting, but it'll definitely apply to every meeting after it, to the extent that it's actually approved.
Yeah.
So that's, I suspect where all of that's coming from, all of those sort of things. So probably adjourned meetings, because what happens if you don't have a quorum is if the meeting's adjourned at the same time, same place next week, and then whatever's there is whatever's there. So it effectively allows another week for people to get organised, to get involved and vote and all that sort of stuff. So there may be less if bodies corporates adopt electronic voting and change their quorum, or potentially even just do electronic voting. You're more likely, I think, to probably get the 25% of people there under the current pro forma regime, which means there's probably less adjourned meetings anyway.
And it comes from the Latin quorum, where it looks as though original usage was back in the 15th century. From the Latin to mean of whom. Okay, there you go, of whom. We've just popped in a very general definition, the Oxford Dictionary definition there, which I think is a really useful one, because whether it's a body corporate quorum or any other type of quorum, that's a really good definition, the one that we've popped up there. Let's plow on. From Wendy on the live chat. Wendy, thank you for tuning in. Who's responsible for screen doors? Front laundry, bedroom, beehive style on all units, no records available as to who, when, all screen doors installed. And it's accommodation module building format plan. What do you reckon, Frank?
I don't. This is back to, I suppose, when I joined the conversation. That can be really messy in terms of maintenance, I think, responsibilities and installation. And you also have to go back in time to a degree. So to the extent that sometimes, and so this is, again, why these disputes are number one in the Commissioner's office, it does depend a bit on the plan format. It depends on whether those balconies are exclusive use areas or people's lots, or they might just be straight common property, which surprisingly enough does happen.
Yep.
And it also depends who actually installed them. I think, as you pointed out there, the developer might have installed them, owners might have installed them subsequently. So it's an interesting one in the sense of, if something was originally a body corporate responsibility and an owner chooses to remove that and put their own thing in, that responsibility then rests with the owner. So in Strata land, we have quite a few issues of these over time, particularly when records have been lost or there's no records at all, because things have just happened, about who's actually responsible for what. It gets very, very messy.
Yep. A few questions coming in. That's good, but we'll go back to one that's been supplied beforehand, then we'll come back to a couple of the live ones. Is it proper for a body corporate manager to A, share your email with other members of their non-professional staff, and B, send your email about a concern or complaint of another resident to that resident? Well, I'll start with the B component. If you're going to complain about someone, then we go back to what Frank and I were talking about earlier about due process. If you're going to complain about someone, then surely you have to give them the right to respond to the complaint. So how would they respond to the complaint unless they had a copy of the complaint? But typically the way that would be done is that you would ask, is it okay if I now provide this on to the other party? What do you reckon, Frank?
Yeah, agree. And probably the other difficulty is that anything that goes into a body corporate manager in relation to a body corporate, short of it being privileged, like legal advice, for example, becomes a body corporate record. So if you write to the body corporate manager saying this Chris Irons is a complete fabrication and he shouldn't be out here anymore and blah, blah, blah.
As if anyone would say that.
That's there on the record. So that is then searchable by any other lot owner. So the fact you even communicate with a body corporate manager in relation to a body corporate issue means effectively that whatever you're sending in is fair game. That's the reality of it. In terms of the body corporate manager sharing the email with other staff members, that's probably a little bit questionable in the sense of, I suppose it depends on what their policies are internally, but the same as a client might email me in relation to a particular issue. I don't go sending it round to the whole of the office to say, get a load of this. Although clearly that might be the context in which it was sent around. But I would have thought that the body corporate manager should only deal with the issue based on the instructions of the committee, because that's who they're actually reporting to. So if you wrote in a complaint about Chris.
I'd want to know why they sent it, or why they allegedly sent it. I also would be interested to know how you found out that as well. But yeah, maybe if they sent it to other members of staff so that they could deal with the issue, well, that's reasonable. But if they sent it with, as Frank said, a note saying "get a load of this," then no, that's not a reasonable outcome, I would have thought. Back to live questions. Aaron, thank you for tuning in. If one person has put insulation into the ceiling, does that then mean the other owners are responsible for the insulation above their unit, or is it still the body corporate to do it? Depends where they've put the insulation, Aaron.
Is it part of their lot?
Yeah.
Is it in the roof cavity that's a building format plan?
Or is it common property?
Mm.
Yeah. Have they made an improvement to common property? But does that mean that other owners are responsible? No, not necessarily, it doesn't. It really depends, Aaron, upon the circumstances, what your plan of subdivision is, what the approval given or was not given by the body corporate to do that. If it's just within their lot, then that's theirs to maintain generally. But it really does depend where the insulation has been put, Aaron. You might like to drop us a line about that one afterwards. I think that's a bit more involved than we can probably answer here. Yep.
The best analogy I could use is if someone paints the feature wall in their bedroom pink, it doesn't mean you've got to do it either. So if that's a private choice they've made, so be it.
Yep. Another question that we got beforehand. One of our lot owners has applied to have a storage tool locker erected on common area in front of their allocated car park. The Billy Corporate Committee approved the application on the grounds it didn't exceed the 3K threshold. Does the area have to be deemed exclusive before approval is given?
Well, I think if you're going to allow someone to construct something, it's got to be on property they actually have the right to use, either by it being part of their lot or the title to their lot, or an exclusive use area. And I suppose if it's an exclusive use area, then I think you need to look at whether the grant of exclusive use actually allows them to construct whatever it is that they're asking to construct in that area. Because the exclusive use grant might say you can only use that area for car parking, in which case you can't use it for storage. But if it's not theirs, effectively what you're doing is just disposing of something that is common property owned by all owners, and that should only really be by a resolution without dissent, because you're giving away the right to use something that isn't theirs. It's everyone's.
Yep. Yeah, I think that's more or less right. Gosh, we've almost run out of time. When did that happen? We've got one more question that came in live from Tom. Kindly suggest a simple and efficient and legal system for the on-site manager to engage contractors and purchase supplies without having to obtain approval from the committee first. I guess that depends upon the terms of your contract, Tom.
It does to a degree, and this is where we use the nasty word in Queensland called delegation. So what every decision that a body corporate makes in Queensland must be a decision of the committee. So this is even at committee level. Some committees will break into subcommittees. You might have a subcommittee for this particular renovation or otherwise. So those people can go and ferret around and come up with plans and tenders, etc. But when that is going to be approved, that still needs to go back up to the committee itself to say, yep, we're happy with that. It's not for those individual people to do it. So from a management rights perspective, it's the exact same thing. I think probably the legal position is that a resident manager really shouldn't be engaging contractors on behalf of the body corporate unless there's a direction and decision from the body corporate committee to actually do that. I shouldn't be, as a resident manager, engaging a new pool company under a 12-month contract or for whatever it is, unless the committee has actually instructed me to do so. So I think the best way to deal with that process is to have some sort of reporting or approval mechanism, ideally in the Strata management software somewhere, where you come to a committee meeting and say, the resident, we need to get a new pool person. Can you please go get some quotes? Got quotes gone and got, recommendation put up. I recommend we choose person A. Committee says, absolutely, we resolve to do that. Then the resident manager goes and puts that into effect on behalf of the committee, acting on their instructions as opposed to in their own right. Really important distinction, but that's the way legally it must work.
Yep, I couldn't have put that better myself. We have come to the end of our session today. As always, time flies when you're asking a whole bunch of questions. I think
or when you're only here for 20 minutes of it. So I know that's my shout. I apologise, everyone, again.
Let us never speak of it again. we'll probably run another one of these in the not too distant future, because it's always a good, while we like the structure, and I think while everybody likes the structure of a dedicated topic each week, sometimes there's just a situation where people just want to ask questions and general questions. So stay tuned for the next one of those. But next week, Frank, we're going to talk about the mysterious world of a BMS.
Building management statements and how they apply to bodies corporate. Absolutely. So that'll be really interesting. And we're working through next month's topics now, and we are going to do, I suppose, committee comings and goings, getting on, off, removal from committees, because there's been a hell of a lot of questions about that, not necessarily pursuant to the new modules, because there's not too much change in that context, but just generally. So that'll also be an interesting one.
Definitely. So please, as I say, make sure that you register on the link that gets sent out so that you get reminder for that, and also the reminders for the next set of topics. But otherwise, thanks everybody for tuning in. Frank, thank you.
Thank you, everyone.
We will see you all next week. Bye-bye.
Cool. Bye.